In terms of my own background, thanks so much for the introduction. I have a mixed practice. I'm an associate with the law firm of Whitten and Lublin, and when I say I have a mixed practice, I mean I practice for both employers as well as employees. One of the things that I'm finding comes up on a fairly regular basis is not only discrimination in the workplace, but how discrimination comes into play from the employer perspective. Recently on a number of issues, we've had some questions from the tribunal about perceived mental disability and how you deal with that in the workplace. So I was pleased to have an opportunity to look into this issue a little bit more and share my thoughts and findings with you this morning. In terms of an overview, let's just see if I can get this to work. There we go. So what I'd like to do by the end of the presentation today would be to sort of overview the 5 following things. So just a quick overview of discrimination in the Ontario Human Rights Code, disability and perceived disability, the issue and idea concept of constructive knowledge, what that means, and then applying that in some of the case studies, and then towards the end of our time together, some practical considerations and some questions. Some of these are relatively scary. When you look at the actual statistics on the prevalence of mental illness in the workplace, it's really a lot more prevalent than you think it might be. One of the ones that sticks out for me of all of these particular statistics is the last one. So not only that over 10% of Canadians are diagnosed with mental illness each year, but if you look at the very last statistic, that nearly 50% of all depression cases are unreported. So when you take these into account and you look at the number of people who are employed within Canada, you start to understand that there is a relatively prevalent degree of mental illness in the workplace, and it's something that we need to start dealing with and looking with a bit more. What that means from an employer council perspective, though, is of course, when you're looking at those statistics in context, a lot of the time those disabilities may show up in things like the Ontario Human Rights Tribunal through the form of a complaint. And when we look at the actual statistics from the Ontario Human Rights Tribunal, between 30 and 50% of all human rights complaints are disability related and employment. And that's a surprising number when you stop to think about it. Nearly half of all human rights complaints at the Ontario Human Rights Tribunal deal with disability and employment. So that's not 50% employment, that's 50% disability and employment. That's a really high number. So as sure as most of you know, because I've been told that most of you are practitioners this morning, the Ontario Human Rights Code makes it very clear under Section 5 and 9 that every person has the right to equal treatment with respect to a number of enumerated grounds, one of which is, of course, disability. Under Section 9, as the employer obligation, no person can infringe those rights. What gets a bit more interesting is sort of what does disability mean in the context for the Ontario Human Rights Tribunal? And it's 2 things. So it's been defined as a condition of mental impairment or a developmental disability, and it also includes a mental disorder. The following have, when we go through the cases, been recognized as actual mental disabilities at the Ontario Human Rights Tribunal. So it's a wide variety of issues, from migraine headaches, chronic pain, psychological problems, adjustment disorder, and the ones that are really concerning from the employer perspective, depression, stress, anxiety, panic attacks, and adjustment disorder, because these can be relatively prevalent in the workplace. The other thing that gets a bit challenging is it's not only discrimination based on actual disability, but it can also be discrimination based on perceived mental disability. So the code is really clear that it includes protection not only for disability itself, but for past, presumed, and perceived disabilities. And in our practice, we were finding that this is where we were running into a bit of a challenge when we were representing employers, was this particular carve-out for past, presumed, and perceived disability. Effectively what that means is that if an employer disciplines, dismisses, or otherwise deals with an employee differently due to a perceived disability, this in and of itself is going to be a violation of the code. So if you have a perceived disability and you're treating the employee differently, that in and of itself can be a violation of the code, which caused a lot of our employer clients a lot of questions. Well, at what point do we know? What point should we know that there may be a perceived disability? How do we deal with that issue? The presenter following me, Keith Scher, is actually giving an entire discussion on accommodation in the workplace. So I want to leave this topic for him to discuss in detail. But effectively, as you will know, once the employer realizes that there is a disability or a triggers a duty of accommodation. So even if the employee does have a disability in the workplace, they must be accommodated up to the point of undue hardship. But part of the problem with dealing with mental illness in the workplace is that it poses specific challenges. It's not like your regular, for lack of a better word, disability. And part of the stigma surrounding mental illness itself means that it may be very difficult for the employee to discuss either the fact that they believe that they have a disability, they may be reluctant based on stigma to discuss the disability, or they may be not able, based on the disability, to actively advise the employer that there is some sort of disability which requires accommodation. More problematic still for an employer is that the employee may deny that anything is wrong. So the employer might deny that there's anything amiss. The employee may decide that they're under the impression that there is nothing wrong. And that can be really challenging when you're putting that in context of perceived disability obligations under the code. So effectively, what do you do when the employee says, you know, there's nothing wrong, I don't think there's a problem, I don't think I have anything, and the employer's obligation to accommodate once they know or ought to know that something's amiss. And that brings us to the idea of constructive knowledge. And I've said, you know, the tagline to it, in other words, ignorance isn't bliss. But the idea is, what happens when the employee doesn't mention